A 200-page full and detailed judgment explaining how the Maraga-led bench of the Apex Court reached the unanimous decision validating President Uhuru Kenyatta's victory in the October 26th poll. The judges, tackling 8 of the 14 KSUs brought before them in the 2 consolidated petitions by former Kilome MP Harun Mwau and activists Njonjo Mue and Khalef Khalifa. What was the import of NASA leader Raila Odinga's withdrawal from the State House contest and his inclusion either way on the ballot paper?
We don't think so, as one cannot be forced to participate in an election in which he or she has lost interest. The NASA candidate, in our view, not only made a public announcement of his decision to withdraw from the elections, but addressed a formal letter to that effect to the first respondent. Such action, in our perception, constituted a substantive and legally effective withdrawal from the elections.
The petitioners had taken issue with the non-participation of 25 constituencies in the polls over what IEBC chair Wafula Chebukati attributed to security concerns and bouts of violence. The judges' ruling, therefore,
those who intentionally instigate and perpetrate violence must not plead the same violence as a ground for nullifying an election.
And should fresh nominations have preceded fresh elections?
We find no fault with the first and second respondents' decision not to conduct fresh nominations. It was a decision fully in keeping with Raila 2013 and later the Ekuru Aukot decision.
The constitutionality of Section 83 in the Amended Election Act also coming into question, Deputy CJ Philomena Mwilu arguing the matter is still before the High Court. Justice Njoki Ndung'u, though concurring, was of the opinion the matter should have been dispensed with at the Supreme Court.
We leave the issue of the unconstitutionality or otherwise, or invalidity of Section 83 of the amended law to the determination of the High Court, where the matter is currently under consideration. In stating so, we see no prospects of the High Court making a finding that would affect our determination of the present presidential election petition.
And on irregularities and illegalities claimed,
the court has not been persuaded that the respondents violated the applicable electoral law in the management of the 26th of October 2017 election.
And shortly after the Supreme Court invalidated Kenyatta's victory after the August 8th election, an irate President Kenyatta took a swipe at the judges.
Ukweli wale wazungu mnataka kuita wakuje wawe observers Maraga, hiyo story tunasikia mnapanga na Odunga huko ati mtaenda kusema IEBC iwe disbanded. Don't joke with Kenyans. We are not cool.
Remarks that were followed by claims of intimidation. But in their ruling today,
and we are speaking for ourselves in this regard, that no judge of this court was intimidated by the choice of words by the third respondent.
The CJ wrapping it up by giving poll body IEBC a clean bill of health.
The election held on the 26th of October 2017 was credible and met the constitutional threshold that is required of a presidential election.
From where the Supreme Court sits, the matter is now as good as closed, but the full and detailed judgment contained in the 200-page document now setting out the political trajectory of the country in as far as any future presidential petitions are concerned in the highest court of the land. Jackie Maribe, Citizen TV at the Supreme Court buildings, Nairobi.